Hey guys, welcome back. Joe Brunsman, Insurance Broker to the Stars here. It is a late night, but a bunch of new clients. That's a good problem to have. Okay, with that, I'm going to be talking about some considerations for you as an MSP when your client comes to you and they say, hey, we think we have something going on or something is going on, some type of cyber event. So generally that could be some type of cyber crime. That could be some type of ransomware event. Could be some type of data breach. So let's go ahead and jump on into it. Before we do, you guys know the drill. That's my latest book, Damage Control, Cyber Insurance and Compliance. That's the link where you can download for free 500 pages of everything you ever wanted to know about that topic. All right, next here, let's talk about starting assumption before we get too much further into here. I'm just going to assume that you have an appropriate tech E&O policy. If you don't, the entirety of this presentation could be absolutely meaningless for you. So before we go any further here, if you have an E&O policy and a cyber policy or just an E&O policy, please go back and check. I'll put a link right above me here. Please go watch that video and then come back to this if you don't know if you have an appropriate tech E&O policy. All right, moving forward here. What are you likely allowed to do in one of these circumstances? Now, obviously, it depends on the fact pattern. It depends on your client. It depends on what they're saying. But we're going to talk kind of broad brush here. What are you likely allowed to do? Well, it really just boils down to, hey, what's the definition of professional services? Are you going to be doing something that if a claim later arises from those actions, you are reasonably going to have insurance coverage for that? If not, then just carte blanche. You just don't want to do it. Make sense? What is the definition of professional services? Well, broadly, it's, hey, if a claim arises and a client makes an allegation, right, those allegations have to fall within the definition of professional services. So here's an appropriate example for you. Professional services mean technology services, blah, 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 for others for a fee. Technology services means, and this is just the key part here, you'll see the points in green: disaster recovery, record retrieval, repair or maintenance of computer products, networks, or systems. So now, think broadly. It's not what you would define that as. Let's think about what would a jury of non-tech people or a non-tech judge, maybe a judge who doesn't even write his own emails, what would he reasonably construe those terms to actually mean, right? Think about that. Next, what are you likely not allowed to do? Well, you probably can't give any legal advice. Now, I have not run into any law firm / MSP. I mean, maybe there's one out there. If you are, I don't know, hit me up. I'd just like to talk to you because I think it'd be interesting. But you probably can't give legal advice. And I don't think a lot of MSPs are going to be giving legal advice. But where could you go afoul? Making some type of legal determination, or what could reasonably be construed as a legal determination or a pseudo-legal determination. What do I actually mean by that? Hey, client comes to you. Is this a data breach? Well, data breach is actually a legal term, generally access and acquisition of information that was supposed to be protected. Are you doing some sort of informal risk of harm analysis that could come back and bite you? Risk of harm analysis, also known as safe harbor events, those are actually found in breach notification laws in most states. So you don't want to run into this area where it's construed as you making a risk of harm analysis, which could be in actuality a legal determination. So if a client comes to you and they're like, hey, I got this thing going on. Like, do I need forensics? Do I need an attorney? What'd you find out? Like, hey, am I going to have to notify clients of this particular issue? That's when you really got to step back and you have to say something to the effect of, this is what we found. This is what we did. But, we're not attorneys. We're not forensics experts. You should highly consider going and reaching out to your own cyber insurance company. If you don't have appropriate in cyber insurance, and we'll talk about that here in a sec, then you need to go out and get those vendors to, give you the appropriate determinations and advice there, because we're just likely not qualified to give you any sort of legal determination or give you any sort of legal advice. Now, what can you likely do? Kind of three key terms here. Identify, like, hey, you see something going on. you should probably tell somebody about that, right? You can say, hey, we think this is occurring, or we have a reasonable belief that something bad is happening. I don't think that that's very risky for you. Next, can you probably contain that threat? Hey, you're sitting there on a workstation and you see the file start getting encrypted, so you rip the Cat5 or I guess potentially Cat6 cable out of the wall now, and you turn that computer off. Can you do that? That seems pretty reasonable. You see something going on with a server. Can you shut that server down? That seems fairly reasonable. After that point, don't give legal advice. Don't make any sort of legal determinations or something that may later be construed as a legal determination. From that point, you should probably just refrain. So those are 3 key terms there: identify, contain, refrain. So let's talk about how all of this boils down into some scenarios. So let's say a client gets hit with ransomware and they end up paying that ransom. They go, hey, we got hit with ransomware. What should we do? And you go, man, you know what? All of your backups have been encrypted, or potentially you didn't have any backups like we told you to, so you're just going to have to pay that ransom. And then it turns out that strain of ransomware was on the OFAC sanctions list. So now your client has paid a state sponsor of organized terror because of that ransomware event. They track that stuff, right? They track those specific cryptocurrency wallets. Who's going to be liable for that? Well, probably directly it's going to be your client. Are they going to turn around and try and bring that claim against you, or could their cyber insurance company try and subrogate those rights and bring it against you if you were the one that told them that they had to pay that ransom? Just an offhanded comment like that, that could be held against you. So please make sure you're taking this seriously. Next, client gets hit with ransomware. And you go, hey, you know what? Great idea that you paid for those backups. We're just going to restore the backups here. And then it turns out that there was some type of attack loop and they get hit with ransomware again. It's the same strain of ransomware. So now they're down yet again and they have to rebuild yet again. And there's all those bills that they have to pay. You guys know how this works. Who's going to be liable for all that downtime? Do you think they're going to come back against you if you said something to the effect of, hey, don't worry, this is why we have backups, we're just going to restore from backups, when no forensics work was done, there was no legal determination, risk of harm analysis completed? Could that come back against you? I'd say reasonably it could. Next, client gets hit with a data breach and they don't have the appropriate cyber insurance, or they don't hire the forensics guys or the attorney to make those determinations. And they go, hey, you know what? It looks like we've got someone in our system here. Do you see anything that was stolen? And you sit there and you go, hey, you know what? I think you're good. We saw no weird outflows of information. And so, yeah, it doesn't look like you have anything else you got to do here. We're just going to get everything back up and running. We might just go ahead, maybe change some passwords, and then you should be good to go. But it turns out that later on, a bunch of clients start reporting they've had their identity stolen. So now your client has to go out and actually get the forensics and the attorney who's competent in this particular area. And those guys are going, you saw this, potentially like last month. We need to look over your risk of harm analysis because there's a high probability that regulators are going to come knocking because now we've notified people outside the bounds of the specific time requirements as stipulated in the breach notification laws. So then the regulators come after your clients with potentially 6-figure fines. Are those fines and penalties insurable? It depends. That's a whole nother conversation. But effectively, nobody really knows by this point because the case law just isn't there yet. Your client gets hit with those huge bills. What do you think is going to happen? Are they going to try and come back and bring that against you? Because you offhandedly said, hey, you know what? We don't see anything here. I think you're good. They could very well do that. When there's a bunch of money on the line, people get very irrational and they get very mean very quickly. And I've seen a whole lot of that in this industry. So please don't fall into these kind of off the cuff, offhanded comments of, I just think you're good, and you just leave it at that. That could really come back to bite you. And of course, if this goes sideways, what are questions you don't want to be answering? What are questions where if you were sitting up on the stand under oath and the client's lawyer starts going, hey, tell me about your computer forensics credentials. How are you going to stumble through that? Are you actually certified to be a forensics expert? Do you have any history doing that? Hey, tell me what hardware, software, the specialized hardware and software you use for this forensics work to make that risk of harm analysis or to make that legal determination when you said that this was not a breach. Even if it was an offhanded comment, they could still come back and they could hold that against you. Next, hey, what were the steps that you took in the risk of harm analysis? Was that appropriately documented for my client? You see where this is going. This is just a liability landmine that you don't want to fall in, so you really need to be quite careful there. Now, who really owns a breach, right? What does this really boil down to? Well, yet another reason why your client should have cyber insurance. You can pause the video and read here. I just pulled out 2 states. What does this really say? Data holder versus data owner. Generally, your MSP is going to be the data holder. The data owner is going to be your client and all the information of their clients. So if something happens, hey, who's responsible for breach notification, credit monitoring, et cetera, et cetera? It's going to be those guys, right? It's going to be your clients. Now, what's your responsibility here? It says the entity that does not own the data, so that'd be the data holder, probably your MSP, shall notify the owner or license holder of the information of any breach of system security immediately after discovering the breach if the sensitive PI was or is reasonably believed to have been acquired by an unauthorized person. Next, you'll see California here. You can pause the video. Essentially the same thing. So in total, remember, identify, contain, refrain. I would highly encourage you guys, consider reaching out to a competent attorney in this area. Start going through some of those various scenarios. Have him look at your policy. Start talking with him about, okay, what can we say if? What can we not say if? Right? And start working through that to make sure that you're staying within the bounds. If you haven't had to deal with this yet, you're going to in the future. If you've already dealt with this, please go back, start looking at those client communications and thinking, okay, what did we say? What did we not say? Is there some way that this could come back against us? Because I promise you, there is a reason that Techie insurance for MSPs is getting more expensive. And there is a reason that cyber insurance is up something like 40+% this year. It's because this is a serious issue. So when there starts being large losses on the table, when there's many frequent losses on the table, insurance companies, clients, they're going to start pointing the fingers. And you don't want them to point the finger at you, especially if you were just trying to be a good person, but you made an offhanded comment that could really come back and bite you in the butt later, as it turns out that you stepped on some sort of liability landmine. So in total, make sure you know what you are allowed to do. Don't just take my word for it. I'm just a bubblehead right here on the internet. I'm just a guy. I'm not giving any sort of official insurance or legal advice. Know what you are not allowed to do, possibly even more important than what you're allowed to do. Make sure you understand what the rules of the game are. If you know the rules of the game, you can play the game. If you don't know the rules of the game, you're probably just going to lose. When in doubt, see competent legal counsel. Like I said before, start thinking through these scenarios. What are you going to say if a client comes to you and they go, hey, a bunch of clients came to me and they told me that I had my identity stolen. Do I have a data breach? Right? What are the actions you're going to take? What are kind of the prescribed client communications that you should have, just kind of the stock answers on hand moving forward? Because that is really going to be crucial for you. Once again, this is but yet another reason why your clients should have cyber insurance. Ideally, those costs are going to be pushed off to the cyber insurance company through an appropriate cyber insurance policy. That's going to make the discussion, if you effectively say, hey, this is what we saw, this is what we did. From this point moving forward, we're not forensics experts, we're not attorneys. You really need to consider talking to your cyber insurance company. Just go through the motions, because as good as we are as an MSP, this is a very specialized area of the world, and you really need the forensics guys, and the competent legal counsel to assist you moving forward. Best case scenario, we were right. Worst case scenario, hey, it turns out that we were wrong because there's some little splinter somewhere or some nuance somewhere in this totally dissociated, highly specialized field that we missed. But if that happens, your cyber insurance should still be able to take care of you. We don't want you missing deadlines. We don't want your clients getting angry. So with that, reach out to your cyber insurance company, have them advise you as appropriate. All right. And once again, have an appropriate tech E&O policy. This whole presentation is effectively moot if you don't have an E&O policy or if you don't have the appropriate E&O policy. So make sure you keep that in mind. All right. With that, man, it is a late night here, so I am done. Right above me, the evil AI will put another video that I'm sure that you will love and enjoy from yours truly. And if you click over there on my face, you can actually subscribe to my channel. I try and put out a new video every week, but I'm writing a book, so cut me some slack. All right, with that, guys, hope you enjoyed this. Stay safe out there.